ask Mr. Martin to basically outline the philosophy of the report which preceded the act.
Well, as is pretty well known, this act, the Bail Reform Act, is the legislative implementation of the recommendations of the Ouimet Committee, of which the Honorable Mr. Justice Roger Ouimet was the chairman. I'm very happy to see him here today. The central theme of the report of the Ouimet Committee was that the purposes of the criminal law should be carried out without interfering any more than necessary with the liberty of individuals, or to put it in another way, that the criminal law should afford the maximum protection to members of society, but inflict no more harm on those who are subject to its processes that were necessary. And all the recommendations of the report are really affiliated upon this theme. The committee was of the view that their arrest was too widely used and resulted in unnecessary detention, that many people who should have been released were not released, and that the coupling of release with monetary considerations really resulted in some people being released who ought not to have been released, and a great many people not being released but kept in custody who should have been released. And this produced discriminatory results. Also, that some of the rigidities that had grown up around the bail system, such as requiring deposit of money or valuable security, or showing title to real estate by production of title deeds, certificate of title, and things of that kind, were completely unnecessary and resulted in undue hardship and delay. The committee thought the problem of unnecessary pretrial custody could best be attacked by attacking it at its source and reducing unnecessary arrests. And consequently, the new act provides that in certain kinds of offenses, generally the less serious indictable offenses and summary conviction offenses, arrest shall not take place unless it is required in the public interest. And if arrest is required, the person arrested should be released as soon as possible. And here again, the general theme of the act comes into play. The basic philosophy of the Bail Reform Act is don't do anything more to the suspected offender than is necessary to protect the public and to ensure his appearance for trial. Don't arrest in the first instance unless it's necessary in the public interest, but in lieu of arrest, issue a summons or issue and serve a notice to appear. If arrest is necessary in the public interest in the first place, then the defendant should be released as soon as possible when the public interest no longer requires his detention. As the committee pointed out, sometimes arrest is necessary in the public interest. If an officer suspects the person to be in possession of narcotics or burglar's tools, obviously tapping him on the shoulder and getting his name and address and issuing a summons is not a very wise use of police power, because you have to make an arrest in the first instance to attract the right to search. But once the public interest has been satisfied in that respect, then it may be perfectly proper to release the suspect immediately. And here again, the fundamental theme operates that when the accused is released, he should be released on the least onerous condition that will procure his attendance in court. The court is required to, in the first instance, make a decision, really, as to whether or not he should be released at all. But once the court comes to a decision that he should be released, then he should be released on the least onerous condition that will procure his attendance in court. No rule, no court, so far as I am aware, had ever really articulated the rule that there was an onus under the previous law of bail on the suspect to convince the court that he ought to be released. But in practice, the fact is that the onus was, in practice, on the defendant to satisfy the court that he should be released. The Ouimet Committee thought the onus should be reversed and should clearly be stated to be on the prosecution to justify the further detention of a suspected person, so that you start off that the defendant should, if his arrest was in the first instance necessary in the public interest, he should be released as soon as possible unless the prosecution justifies his further detention, and he should, unless some more onerous condition is necessary in the public interest, he should be released simply on his undertaking to appear. Now, that's the basic philosophy of this act. The fundamental philosophy is quite simple, although necessarily the act is somewhat complex because of the necessity of integrating it with the present provisions of the criminal code. But it does seem to me, once the fundamental philosophy is grasped, that the onus is on the prosecution to justify arrest and detention, and that the accused should be released on the least onerous condition that will procure his attendance in court. The act becomes comparatively simple.
Mr. Scollin, being presented with the philosophy as outlined in the Ouimet report, how did you go about attempting to draw up the act, and how did it come to its present form?
Well, first of all, we took a pen, and then we, in fact, performed the function of really an amanuensis for the Canadian Committee on Corrections. You've sat through today, and you can see how closely to the philosophy expressed by Mr. Martin, the bill actually comes. Basically, we aimed for three things. First of all, avoid unnecessary arrest. And that was done in two ways. Firstly, by putting an obligation on the officer on the street, and secondly, by putting a duty on the justice at the time he gets around to considering whether or not to issue a summons or a warrant. As far as the officer on the street is concerned, the duty was imposed on him in a relatively minor type of offense, not to arrest unless certain cumulative conditions were satisfied. Firstly, that it was necessary in the public interest, and secondly, that there was nothing in his head to indicate that the guy wouldn't show up. We weren't expecting him to do a positive forecast and, for example, take bets on whether the guy would or wouldn't show up. But firstly, if there was no grounds in the public interest that made arrest necessary, that part of the test was satisfied. Secondly, if he had no reasonable grounds for believing the guy wouldn't turn up, the second part of the test was necessary, and his duty emerged not to arrest. That's Section 450. Section 451 give him something to do when he makes that decision. If it's one of these minor offenses, he can haul out his paper and give the guy an appearance notice. Otherwise, he goes back to the police station, tells his boss that I found this guy doing this and this, and I think we should summon him, or else I think we should arrest him, and the procedure goes on in the ordinary way from there. But in these minor or less serious offenses where he decides not to arrest, he's got this piece of paper that he can give to the guy called an appearance notice. As far as the justice is concerned, under the law as amended by the Act, instead of having an unfettered discretion about whether or not he gets the guy hauled into Huskow on a warrant or issues a summons, an obligation is put on him to issue a summons. Hell or high water, no matter what case, no matter what type of offense, an obligation to issue a summons unless, and the unless is unless it's shown by the informant or the witnesses that are heard that arrest is necessary in the public interest. So there on the non-arrest aspect, like don't pick up guys, on that aspect you've got first of all the duties on the arresting officer not to arrest, the duties on the officer on the street not to arrest, and secondly the duties on the justice to prefer summons to warrant. Then the second major area, don't detain him unnecessarily. This has been done by imposing three major duties on the police. Firstly, on the guy who does arrest, the officer who does arrest, let the fellow go as soon as practicable. You've had a chance to look into his background, phone his employer, phone his girlfriend, phone his wife, phone both of them. You've got a chance to check up on the guy. eh? All right, a duty on you to get him out. All you can give him is still either an appearance notice, but if you don't have reasonable and probable grounds to keep him, let him go. If you're worried about letting him go yourself, if, for example, you think there's a chance he may skip or else he should be detained, he's a real rotter and a bad egg, then you can refer it to your officer in charge, and similar obligations are put on him to consider the case from the point of view of release. And his obligations extend not only to these minor offences, but to anything, any offence that carries 5 years or less. So there's your two situations, your officer in charge in relation to minor offences with a duty to release, your officer in charge in relation to any offence up to 5 years with a duty to release. And then thirdly, in relation to getting the guy within the wheels of justice as quickly as possible, assuming all of this hasn't worked, and assuming the case is either 5 years or less or more than 5 years, a duty to take him before the justice without unreasonable delay. The act is framed in such a way that it's no longer just a standard 24 hours. The officer can't say, oh, well, hell, we've got till 9 o'clock tomorrow morning. The duty under section 454 is to take him before the justice without unreasonable delay, and in any event within 24 hours. Having got him there, the guy hasn't been released, he's been through all this mill, he's still in custody, he's before the justice without unreasonable delay. The justice now has an actual obligation to release. It's not a question of saying to the accused, well, laddie, what do you say? Any reason why I should give you bail? No, it's an actual automatic release, unless the justice shall release the accused on his undertaking without conditions. No stories about him reporting to the police or staying away from the bar or anything like that. He shall release him on undertaking, unless, and here again, the onus put on the Crown. The Crown's got to show why the guy should be kept in. And then again, in line with the Ouimet Committee report that Mr. Martin mentioned, if the Crown is going to ask for anything more than a piece of paper that says, yeah, Judge, I'm going to come to court, then the Crown's got to show it, and the justice has got to be satisfied that in a gradated series, the methods of release will be the least onerous. An undertaking, first of all, without conditions. If the Crown manages to show that's not good enough, then it's an undertaking with conditions. And it's only then that you get into the reconnaissance. The undertaking, no question of the guy owing the Queen $500 if he doesn't turn up for trial, no debt aspect at all. It's a straight new concept of, yeah, here's my word, I'm going to come to court. Detention can only be justified on the specific grounds that are set out in section 457. Those are the only statutory grounds, and the primary one, and the one the justice has got to decide first, is it necessary to get the guy to court? And it's only if he's decided that the Crown hasn't shown that that's necessary that he goes on to consider the public interest, or the protection or safety of the public. And even here, a broad indication is given that it's not any old public interest will do. You can't hold a guy just because there's a possibility, you conjecture, that he might, in a day or two, commit theft of $2.50. It's got to be a substantial likelihood of an offence involving serious harm or an interference with the administration of justice. So it's not any old public interest you're talking about. It's a relatively serious public interest that's got to be preserved. Then thirdly, so much for the guy. You've got him out as quickly as possible. If he's not out, get his trial on as quickly as you can. So new provisions providing that in the case of an indictable offence, 90 days from the time of his arrest, or 90 days from the time he was taken before the magistrate. Summary conviction case, 30 days from the time he was taken before the magistrate. If his trial hasn't come on then, his custodian, not the accused, his custodian has got to bring the thing to the attention of the court to get him out. The same kind of rules applied in relation to appeals from indictable offences. Onus spelled out so that it's not just some vague area of divergence between the courts. Statutorily, in the case of an appeal against conviction, he's got to show it isn't frivolous. In the case of an appeal against sentence, he's got to show it work unnecessary hardship, and that it's got some merit. But statutory formulation of these grounds, which conceivably, as Mr. Martin said, could have been developed under the present system or the former system, but weren't. Sorry about that machine gun fire, gentlemen. That's it.